Hello friends, today we are discussing about Workmen's Compensation Act 1923. We have already studied this topic, so basically today we are going to discuss the multiple choice questions which are very important for us. Now let us start with the first question. The first question is, which statement is true of the following four statements under Workmen's Compensation Act 1923? The first statement, individual manager subordinate to an employer cannot act as managing agent. Managing agent include an individual manager subordinate to an employer. Only employer can act as a managing agent. And option D is the appropriate government shall appoint managing agent. So the last statement, the appropriate government shall appoint managing agent, is true in case of Workmen's Compensation Act. Now the second question. Which statement is true? The Workmen's Compensation Act 1923, the Maternity Benefit Act 1965, and the Employees State Insurance Act 1948. These are the three acts, and out of these three acts, which acts can be applicable together? That is option A. B. The Maternity Benefit Act and the Employee State Insurance Act can be applicable at a time. Option C. The Workmen's Compensation Act and the Employee State Insurance Act can be applicable at a time. And option D. If the Workmen's Compensation Act and the Maternity Benefit are applicable, the Employee State Insurance Act is not applicable. So the D option is the correct, that when there is a Workmen's Compensation Act and Maternity Benefit Acts are applied, then Employee State Insurance Act is not applicable. Next question. Now the third question, assertion. Provisions of Employees Compensation Act and Maternity Benefit Act do not apply to all industries. The reason given is Employees Compensation Act is a comprehensive social security legislation. It means that whether the company or the factory is big or small, it is applicable in all kinds of factories. That is the reason given over here. So option A and R are right, and R validates the A option. So maternity benefit is not given in all industries depending upon the scale of the industry, but Employees Compensation Act is applicable in all. So R is validates the A option, that we can't apply Maternity Benefit Act in all types of industries. Now the next question, question number 4. While working at the construction of a multi-storied building of a company, a worker employed by a contractor supplied by a sirdar face an accident and become temporarily disabled. For paying compensation to such worker, who shall be held responsible as per the law? So the right option is the contractor who employed the worker. He should be held responsible for paying the compensation, not the sirdar. Sirdar means the person who is actually supplying the people to the contractor, the foreman who is supplying these workers. So option A, the contractor who employed the worker, is correct one. Now next question. No contribution is required for getting benefit under which of the following legislation? See, there are various benefits like Provident Fund is there, and in the same way there is a Employees Compensation Act, Maternity Benefit Act. These acts, both the acts, they did not require any kind of contribution on the part of the employee. The person who is employed in the company or in the factory, he didn't have to pay from that. Now, next question 6. If the money is due from the employer under the settlement or award, the workman or his assignee can make an application to the appropriate government for the recovery within the period given below. So, the correct option is option B, that within 1 year and also after the said period, the employee can or the assignee can apply to the appropriate government if it is satisfied that the applicant has sufficient reason or cause for not making the application within time frame. Now, seventh question. The name of which of the following legislation has been recently changed? So, as we are studying the Workmen's Compensation Act, the correct option is Workmen's Compensation Act. Its name has been changed recently. Next question. Which of the following statement relating to the Employees Compensation Act is not correct? Which of the following statement relating to the Employees Compensation Act is not correct? Which of the following statements relating to the Employees Compensation Act is not correct? Option A. This act has a link with the Workmen's Compensation Act. Option B. This act is the outcome of the amendment that was made to the Workmen's Compensation Act. This act does not have any provision relating to temporary disablement of workmen. Option D. This act has a provision relating to permanent partial disablement. So the correct answer for this particular statement is option C, which is incorrect, that this act does not have any provision relating to temporary disablement of workmen. So Employees Compensation Act, which has been derived or it is an amendment of the Workmen's Compensation Act, it also includes provision relating to temporary disablement of workmen. Now, question number 9, assertion is there. Industrial accident occur inter alia due to fatigue. It means that if the industrial accidents are occurring and one of the reason can be due to fatigueness to the worker, then the reason is given. Fatigue is the result of personal health condition of the worker as well as by overwork, monotony and boredom as a part of work experience. So the correct answer is option B. A is the right explanation, right assertion, and R, the reason given is the right explanation of the assertion. Next question, question number 10. If there is a willful removal or disregard by the workman of any safety guard or other devices which he knew to have been provided for the purpose of securing safety of workmen, then in this situation the correct option is whether employer is liable to pay compensation. Option B, employer is not liable to pay compensation. Option C, appropriate government is liable to pay compensation. Option D, the trade union is liable to pay compensation. Now, as we can understand from the question itself, as the person has willfully on his own removed or he has not paid attention to safety guard or other devices which he has to use for safety purpose and he's just ignoring them, then nobody is liable to pay compensation to such worker. Okay, so option B, employer is not liable to pay compensation is the correct option. Now question number 11. Under this act, employer shall not be liable to pay compensation in respect of any injury not resulting in death or permanent total disablement caused by an accident. So if the worker is under the influence of drink or drug, that is A option. Option B, due to the willful disobedience of the workman to an order expressly given or to a rule expressly framed for the purpose of securing the safety of workmen. Option C, due to the willful removal or disregard by the workman of any safety guard or other devices he knew to have been provided for the purpose of securing the safety of workmen. And option D, all of the above. So the correct option is that all things are applicable. All of the options A, B, C are applicable. That the employer is not liable to pay compensation to the worker if it results into any injury or death or permanent total disablement due to drinking or taking drugs, due to negligence on his part willfully of using the safety gadgets or devices or following the norms or removing them. All of the options. In case of all this situation, there is no compulsion on the employer to pay any kind of compensation to the workman. Now, question number 12. In case of fatal accident, if the commissioner serves notice to the employer based on his source, so which is the correct option? In case of harmful accident to the worker, if the commissioner serves notice to the employer owner based on his source, so what the employer should do? Option A, the employer can neglect the notice. Option B, if the employer thinks liable, he shall make the deposit within 60 days of the service of the notice. Option C, if the employer thinks liable, he shall make the deposit within 30 days of the service of the notice. And option D, if the employer is not liable, he shall in his statement indicate the grounds on which he disclaims liabilities. So the correct answer over here is option D, that only C and D statements are correct. That if he thinks that he should be responsible and he must pay to the particular employer, then he must deposit the said amount within 30 days from serving the notice. Or if he thinks that he is not responsible for that action and he disowns the compensation, then he should give a written statement to the commissioner. Thank you. Option D is the correct answer. Now let's move on to the next question. Question number 13. Under Workmen's Compensation Act 1923, which of the following are considered as dependent of deceased workman for the purpose of paying compensation? So there are four options given, and the option D, that is all the five options given over there, they are the correct one. That is, any worker who is deceased, so on behalf of him, the dependent which can be considered who are eligible for getting the compensation are minor brother or an unmarried sister or a widowed sister of the worker, a widowed daughter-in-law of the worker, a minor child of a pre-deceased son, means the worker, if he has a son and he has already passed before the worker and he has a child, then that minor child is also eligible for getting the compensation. Then a minor child of pre-deceased daughter where no parents of the child is alive, means if the worker has a daughter and that daughter has passed away and she has her child which is in the custody of that worker and there is no other person to look after that child, then that minor child of pre-deceased daughter is also eligible for getting the compensation. And lastly, a paternal grandparent if no parents of the workman is alive. So grandparents from the paternal side, they are also eligible for getting that particular compensation. So option D with all the 5 options given is the correct answer. Now the 14th question. Under this act, employer shall not be liable to pay compensation in respect of any injury which does not result in the total or partial disablement of the worker for a period exceeding dash days. So options are A option 7 days, option B 3 days, option C 5 days, option D 2 days. So the correct answer is option B 3 days. So under the Workers' Compensation Act, employer is not responsible for paying any kind of compensation for any injury which does not result in total or partial disablement of the worker if the period does not exceed more than 3 days. If it is more than 3 days, then he is eligible for getting compensation from the employer. So these are the important questions related to this topic, Workmen's Compensation Act 1923. If you have any question, please write me to my email. You can see the email agesavde@kkvak.edu.in. Thanks for watching. Enjoy learning. Thank you.